Good morning. I'd like to welcome you to our webinar, our ENS webinar on the interplay between the Competition Act and the Consumer Protection Act, with a specific focus on the Memorandum of Understanding that's recently been entered into between the Competition Commission and the NCC. It's my pleasure to welcome our guest speakers, the ENS speakers and attendees. Just from a housekeeping perspective, I would like to ask attendees to please use the Q&A function if you want to ask questions during the webinar. And if we have time for those at the end, we will address those. It's my warm pleasure to welcome our guest speakers. We have the Deputy Commissioner of the Competition Commission, Mr. Harden Rachasusu, and the Acting Commissioner of the National Consumer Commission, Ms. Tezi Mabuza. I also welcome my ENS colleagues, Ira Gunning and Aidan Scallon. Ira is a director in our Banking and Finance Department with a specialty in consumer protection law. And Aidan Scallon is a director in our Competition Department. So at this time, I would like to hand over to the Deputy Commissioner of the Competition Commission to make his opening remarks, including a sort of a macro view of developments in consumer protection and competition law policy. Thank you, Deputy Commissioner.
Thank you, Alta, for the very, kind and warm introduction. Indeed, it's our pleasure to participate, in this seminar on the interface, I think, between competition policy and consumer protection. I think it is coming at a very opportune time when globally competition authorities are looking into a number of issues, issues of big data, issues of privacy, and ensuring that markets work and do work for consumers. So as you know, competition policy in South Africa has its roots from the desire by the new democratic dispensation to utilize the law to, amongst other things, address imbalances created by past racial exclusions. The Competition Act was first passed into law in 1998. It formed part of the pool of transformative legislations to address the apartheid legacy of legal cartels, state-sponsored monopolies, highly concentrated markets, and exclusion of the majority of people to participate in the economy, and also exclusion of small businesses from its mainstream economy. While the objectives of the Competition Act are primarily developmental and transformative, particularly in the context of South Africa, competition policy is about applying rules to make sure businesses and companies compete fairly with each other. This encourages market efficiency, creates a wider choice for consumers, and helps reduce prices and improve quality. In the simplest way, for a company to gain a market share, it has to offer a better price. In a competitive market, prices are pushed down. Not only is this good for consumers, when more people can afford to buy products, it encourages businesses to produce and boosts the economy in general. Competition also encourages businesses to improve the quality of goods and services they sell, to attract more customers and expand market share. In a competitive market, businesses will try to make their products different from the rest. This results in greater choice, so consumers can select the product that offers the right balance between price and quality. All of these, why we have this kind of focus in South Africa, it's rooted on what countries agreed a while ago. And I can go back, to the 1980, at the United Nations conference, where the UN adopted rules for, which are a set of multilaterally agreed equitable principles for the control of restrictive business practices. So these are the rules that are now guiding what we are seeing in the global world, where a lot of countries are adopting laws to regulate anti-competitive practices, and they have competition policies and their laws adopted. Furthermore, we know in 1985, the UN again adopted guidelines for consumer protection. So all of these are sort of guiding principles broadly, as to why do we see the regulations we have in the country. We did not have consumer protection, it was sort of regulated within different spheres of government. Now we have a statute. We had a Competition Act, by the way, long time ago. That act, of course, resulted in the market structures we see, anti-competitive market structures. Is an act that was found to be ineffective, to regulate competition in South Africa. So we have seen now in the world the rise of competition regulation as we have it in South Africa. We are following many established countries. What we are also finding is that in the region, and I know that in SADC, this is when we engage at SADC level, we engage jointly on competition and consumer protection, which is why I think the discussions today are quite apt, because there is indeed a lot of synergies that we find in these two pieces of legislation. I think in other countries, Netherlands, UK, I think Australia is the oldest. We have a couple in Africa where these instruments are housed in one authority, which sort of confirms the synergies. But in South Africa, currently, the legislature has opted to keep this separate. And that also works, because we do have a lot of cases that we have to deal with from a competition point of view. We do have a lot of cases that we have to deal with from a consumer protection point of view. So it is something that works. That's why you have us agreeing into an MOU to ensure that we can coordinate our activities between the Competition Commission as well as the National Consumer Commission. So this is a very timely discussion because we have had, and I think you have picked up before, during COVID, I think this is where we started working much more closely, as the authorities to tackle, excessive, pricing and exploitation of consumers during the COVID-19 pandemic. So I see a lot of, collaboration into the future between the Competition Commission and the National Consumer Commission. And even the renewal of the MOU, I think, was quite timely. And it is something that it provides, some clarity, provides some certainty there to businesses. And we, of course, it will never be perfect, but it is a system that we will continuously improve. So thank you very much, and I think I'll pause here for now. Thank you.
Thank you, Deputy Commissioner. I'd now like to hand over to the Acting Commissioner of the National Consumer Commission for her opening remarks.
Thank you, Alta, and good morning to our attendees, and thanks a lot to my colleague for the good introduction in relation to the overview of both the competition and the consumer protection policy. Now, as my colleague has said, that looking at what United Nations has laid out as principles within the competition space and also within the consumer protection space, is that, yes, looking at the market, you would find that it's really good to have a fair market, which is very competitive. But if you don't have uptakers of those goods that are being produced by the market, then it's as well as the market is dead. Now, coming back to now the Consumer Protection Act, We know that the Consumer Protection Act emanated from the Unfair Business Practices Act. That really, by that time, didn't do much in terms of offering redress to consumers. It started only by saying that a certain practice would be unfair and then a business will stop that. Then we evolved in 2008, where in the policy, as we have heard, that established the Consumer Protection Act, then was assented to into the act that we have right now. And then that led to the establishment of the National Consumer Commission in 2011. Now, what was the thinking behind the Consumer Protection Act? Is that looking at our legacies of South Africa in terms of us and as consumers and business, is that the first thing that you see is the asymmetry of power between the suppliers and the consumers. That also relates to information when it comes to the bargaining power when we enter into a transaction. So we know that when you enter into a contract, you have to come together as partners wherein you are equal because you enter into a contract. But then when you're looking at now the consumer protection issues, when we transact, that transaction, could it be that we're buying bread or something bigger, wherein you are buying your house, there is a contract, there is an agreement between the consumer and the supplier. But then the CPA wanted to level that playing ground so that if there are disputes, there would be a better way of resolving them. Now, what is the purpose of the CPA? The purpose of the CPA is to promote fairness, openness, and good business practices between the suppliers of goods and services and the consumers of those goods and services. And how do we do that? We do that by promoting a fair, accessible, and sustainable marketplace for consumer products and services. And then we also provide for improved standards of consumer education, and we also promote responsible consumer behavior through making sure that we have consumer information awareness so that our consumers are informed in terms of the choices that they make. But then we operate in a different space from the Competition Commission because our area is an area of concurrency in terms of the jurisdiction. We have the provincial consumer affairs officers that have the very same mandate of the NCC, but then they deal solely with our complaints that emanate from our consumers and businesses that are in their province. And then you also have your sector regulators that in terms of their regulation, they will have the same principles and the same rights that are enshrined in the CPA, wherein they have to ensure that in their own space, when they regulate those businesses, then they make sure that the consumer rights that are in the CPA are also protected. We are talking of those sectors such as your ICASA, your National NERSA. We also have the Council for Medical Scheme, you have the National Credit Regulator, you have the National Regulator for Compulsory Specifications. When you're looking at those sector regulators, you will see that they are operating only in their different spaces, regulators, but the rights of those consumers that are there in the CPA, the CPA goes on further to even say that they have to ensure that the rights of consumers as espoused in the CPA are protected. They even have to go further. And we are even allowed, the minister is allowed even to exempt certain sectors if maybe their regulations or that sector regulator has equal, that you would see also with the Financial Sector Conduct Authority, that when their act has the same principle and over and above that of the CPA, then they can be exempted and be solely now regulated by the sector regulator. And then what we also do is, you would see most of the time would say we promote, but our most important task is to make sure that the legislation for consumer protection is consistent. And then we have to make sure that it is consistent in ensuring that the enforcement framework relating to consumer transaction in South Africa as a unified state is consistent, it's uniform. And then we also make sure, also as the NCC, to ensure that we also create other platforms wherein we make sure that consumer protection is accessible by making sure that we bring it closer to the people, wherein we will recommend certain schemes for accreditation by the minister, wherein you would see that we also have our motor industry ombuds scheme, and then we also have the consumer goods and services scheme. So that is the accreditation to make sure that consumer protection is accessible to the consumers at no cost to them. So our main focus in this instance is to make sure that we offer redress to consumers that have suffered detriment in the process of sourcing and using those goods that are provided by the supplier. I will pause there. Thank you.
Thank you, Acting Commissioner. I think in recent times, what's come to the fore is one of the most obvious areas of overlap between the remit of the NCC on the one hand and the Competition Commission on the other hand is in relation to excessive pricing as we know it from a competition law perspective and unfair pricing from a Consumer Protection Act perspective. And this is sort of melded into that sort of concept of price gouging. I think I'll pause here to let Ira and Aidan give an overview of the law in these respective areas.
Thank you very much, Alte. I'll start off with the CPA and then I'll hand over to Aidan to speak to competition law. So of course, the relevant provisions in the CPA are sections 40 and 48. Section 40 says it prohibits unconscionable conduct by suppliers, such as unfair tactics. And then section 48 says a supplier must not offer to supply or enter into an agreement to supply goods or services at a price that is unfair, unreasonable, or unjust. And then, of course, we saw the Consumer Protection National Disaster Management Regulations, and I'm going to refer to them as the disaster regulations, come out, and they focus specifically at price gouging, and they lay down two tests for the NCC to determine whether price gouging occurred. The first one is for the NCC to prove that the increase in the price of the essential goods did not correspond to or was not equivalent to the increase in the cost of providing those goods. And then the second one would require the NCC to prove that the supplier increased its net markup above the average markup for the essential product in the 3 months before 1 March 2020. And of course, prohibited conduct in the form of price gouging and so on could lead to severe sanctions, including a fine of R1 million or up to 10% of your turnover and imprisonment of up to 12 months. So that is just a brief overview of the relevant provisions of the CPA. And I'll hand over to you, Aidan.
Thanks, Ira. Yeah, so I think obviously excessive pricing has been a feature of the Competition Act since its inception, but in 2019, the section received a significant overhaul. But in essence, what the Competition Act prohibits is a dominant firm from charging an excessive price. But the Competition Act doesn't actually go on to define what an excessive price is. But it does provide some guidance. And I think this is where sort of, I suppose, the amendment that I mentioned comes in. And what that guidance on sort of determining what an excessive price says is that an excessive price is one that is higher than a competitive price, taking into account all relevant factors, which could include, and then the Act lists a number of different factors, which, for example, the price cost margin of a particular good, the internal rate of return of a business, the return on capital invested. It also suggests looking at historic profit margins, as well as profit margins in other markets, the price of those goods in other markets, prices of comparable goods in other markets. And I guess sort of using those factors allows you to sort of try and work out whether the price is excessive or not. As mentioned by Ira, at the beginning of last year, with the outbreak of the COVID-19 pandemic, the Minister of the DTI, or DTIC rather, introduced regulations, I suppose, to provide some further guidance on determining what an excessive price would be, and what those regulations say. Again, quite similar to the CPA space, but they say that where there is a material price increase that doesn't correspond to an increase in the cost of supplying that good, or there is an increase in the net margin or markup of a particular good relative to the average margin or markup achieved in the 3-month period prior to 1 March 2020, then that is a relevant and critical factor to determining whether you have an excessive price. And indeed, it indicates that the price is prima facie excessive. And that's important in the competition space, because the Competition Act, once you have a prima facie case of excessive pricing, there is a shift in the onus. And the party that is accused of excessive pricing then has to show that that excessive price, or that price, was reasonable. I think the very important distinction between the excessive pricing test in the Competition Act and the unfair pricing test under the CPA is that the Competition Act has I suppose a gating mechanism, if I can call it that, which requires, which means that it's only applicable to dominant firms. So if your firm is not dominant or doesn't have market power, then you're not captured or not caught by the excessive pricing provisions of the Competition Act. I think another thing, and this is perhaps just my view on it, and not necessarily one that would be shared by other people, but I think when you look at the factors that are set out in the Competition Act to determine whether a price is excessive, to me they seem to be more quantitative type assessment. So looking at internal rates of assessment, profit margins, those kinds of things. But when you look at the factors set out in the CPA and things that the Act instructs you to consider, they seem to be more qualitative. Whether that sort of ultimately changes the assessment, I guess we can debate. But that's something that I thought was sort of an interesting distinction between the two as well.
Thank you, Aidan. I think leading on from that kind of overview leads on nicely to a question we would like to pose to the Deputy Commissioner. Given the differences in the two tests, this excessive pricing test on the one hand and the unfair, unreasonable, unjust pricing test for CPA purposes, which can capture similar types of conduct, and certainly in relation to the disaster regulations, there was definitely some overlap there. Just practically speaking, how will the Commission and the NCC treat these sort of cases going forward? I think that the question is whether resources will be managed to avoid duplication, or is it your view that if conduct contravenes both acts, it should be prosecuted under both acts? So will there try to be a drive towards efficiency and allocation of matters, or where there is some overlap, there's the potential to actually be found contravening both pieces of legislation?
Thank you, Alta. So I think this is a very important question, because there are always questions around, are we duplicating effort as authorities? And what we have, and this is, I think, a feature of our law, is that, and I think Aidan was getting there. There is we look at this Competition Act focuses on exploitative pricing in the form of excessive pricing, and it has this idea that for those prices to be excessive and be deemed to be in contravention, such a firm should be dominant in a market. But this dominance threshold, I think Aidan says it's quantitative, but I think it's a threshold for me that is can catch any firm. And I think we have seen with Babelech, you know, a firm with 5% of market share, but it could exercise market power. At that time, the Competition Act applied, you know, in those situations. So although the Act says, well, it's presumed, a firm is presumed to be dominant if it has at least 45% of the market share, it does say, you know, for those with lower, you know, market share, they could be presumed dominant. They could be dominant if they exercise market power. So I see this as I think the idea, of the Competition Act is to try to, look at the conduct of the, I suppose, I don't want to say large or small firms, but dominant firms, essentially. Whereas when I look at the Consumer Protection Act, it looks at all firms without qualifications. All right, so what we are required to do there is to collaborate when we are enforcing these statutes. And I think what you have picked up is that, and I think we took that decision, that we will be prosecuting firms that have contravened both these laws, because the cases were a little bit different. So we just didn't want to take a risk that we do not attend the case through the Competition Act. It's attended through the Consumer Protection Act. You could see, there were even some other procedural challenges, in either of these processes. So for firms, maybe what I can say is that there is very little that competition authorities can do, because these two laws apply, essentially, which means when a firm looks at its conduct, it could engage in something that could not be found to contravene the Competition Act, but it could well contravene the Consumer Protection Act. So I think for firms is just to be conscious of these laws and seek to comply with these legislations and price fairly. So I think there would be some criticism. I don't think we can pretty much address this fully, because there will be those cases that we will pursue at the same time, depending on the nature of the contravention, how egregious we think that contravention is. That's why we have this now, what I prefer to call a second generation MOU, where we have deeper engagements on how best to approach certain cases. So what you have seen in the price gouging situation during the pandemic, that was a product of deeper engagement between authorities. We had a joint team looking into these cases to say, how best should we be tackling these cases, of course, within the law. So, and I think, we are in constant contact with the, commissioner at that level, on these cases. So I think rest assured that we at least would try our best. We'll try our best to coordinate our activities when we are investigating these practices. Thank you.
Just one follow-up question, Deputy Commissioner, before we move on to further questions for the Acting Commissioner, the NCC. Historically, so now we're talking pre-pandemic, you'll be very aware that excessive pricing cases were extremely difficult to prosecute. It was very, very few and far between. Obviously, with the success, that the Commission had with these excessive pricing cases during the pandemic, is this a new normal in relation to who is considered to be a dominant firm? Or once we are past the national state of disaster, will we go back to a scenario where it's, possibly only an ArcelorMittal once every decade that is found guilty of excessive pricing? I think for our clients that run businesses, I think they'd be interested to know your views on whether it's a new normal or we'll revert to the previous position post-pandemic.
All right, thank you very much for that. And I think, as I say, if you look, let's look at the purposes of this, the purpose of the Competition Act. And when you look at it, it's looking to address issues of concentration, right? And you could, when you read also the policy intent in the sort of the policy statement that government published, documents that accompanied the amendments, the main focus is addressing market concentration, and also address, those markets with very, with dominant firms, large dominant firms that are stifling competition in markets. So in terms of priorities and prioritization, for the Commission, the priority has always been these large firms. And as pointed out to the cases that we have pursued in the past, the cases against Sasol, SEP, Mittal, those are the kinds of cases we have pursued in the past. With respect to the pandemic, what the pandemic points to is that firms that are in a position of maybe a position that allows them to exercise some market power, they should be conscious of this law. So a firm might look at itself and say, well, I'm small in the bigger scheme of things, but they could well be exercising market dominance in a certain area, in a certain locale. We do have, those cases from time to time. I know we had a case, against in aggregates, a supplier. In the bigger scheme of things, it's a smaller firm, right? But it has some level of dominance in that area, given the kind of product that it is selling. But as you know, we have regulations, the thresholds for dominance are also very low. Also just the regulation on the kinds of firms that you can pursue. I think there's that monetary thresholds of 5 million minimum of turnover. So that kind of a firm can be pursued. So I think what we encourage firms, because a small firm today can be a big firm tomorrow. What we encourage firms is to familiarize themselves with the law and always try determine their pricing behavior in that context, so that they are never found to be in contravention of these laws in future. But you're right, in terms of priorities, if you look at the policy intent, is to address those big structural problems of concentration in the country. And I cannot say, of course, if there's a small firm that chooses to exploit its position for whatever reason, we may be called to intervene. But I think that's where this Consumer Protection Act comes in, because that gap, in essence, is filled by the competition, the Consumer Protection Act. So yeah, I'll leave it there.
Thank you. So, Acting Commissioner, the MOU entered into between the Commission and the NCC earlier this year replaced a previous MOU that was entered into between the respective commissions in 2011. Why was it necessary or desirable to enter into this new MOU? And what is different about the new MOU versus the 2011 version?
Thanks for that question. I think we are all in a developmental stage. So when you start entering into an MOU, you try implementing it, you'll have meetings between yourselves and say, what is it that we want to focus on? So the main focus of changing or of updating, let's say we didn't change, we updated our MOU, was really to look at the synergies and areas of focus. Most of the areas of focus that we wanted to look at, it was around the areas of our investigations, how we can join resources, and how we can also look at our skill set and use the skill set as government being in the same stable to say, how do we then bring our skill sets together so that wherein we would need either maybe the services of an economist that the NCC doesn't have in its structure, then we know that our sister regulator has that. So it was more of that skill set. And also, but what was also essential as well is that we find ourselves in areas that we are moving into, as my colleague has said. When we go outside the borders of South Africa, then we want to engage on consumer and competition issues, is that we find ourselves in the space of one regulator that has both legs in their stable. So it needed us really to talk more often, have regular meetings, have the same understanding when it comes to policy. Even if we would have to recommend some of the papers to the minister, we have to sit together and say, yes, we're talking about the competition issue here, or maybe competition policy, but then it leads as well to better consumer products. So that synergy is for us really to establish based on the MOU, but working together. But what we had also found is that even when we look at some of the matters that we dealt with, like when we looked at the timeshare previously, we realized that we are looking at transactions between a consumer and a supplier, but we realized that there was market dominance in relation to the people that own the timeshares and also some of the contraventions of other acts. So that made it possible for us to say, hey, because here we are seeing that there are people that are dominating in the market itself, to refer some of the matters to the Competition Commission. But we realized that if we would have started with that engagement, getting our resources together, there wouldn't have been a need really to say refer, but we would have seen some of those contraventions and worked at them simultaneously. So if we have bigger cases wherein we collaborate, then we have better ways of coming up with solutions and recommendations as we go along, especially during your market inquiries. So we complement each other, and then we need each other to move forward because we are working in the same market that will benefit consumers. Thanks.
Thank you, Acting Commissioner. As sort of a follow-up to that, you've mentioned, for instance, the timeshare industry. So we're also aware that obviously the Competition Commission identifies from time to time priority enforcement sectors. How does the NCC determine its priority enforcement sectors, if at all? And is it anticipated that in future there could be greater alignment or coordination in the identification of priority enforcement sectors between the Competition Commission and the NCC? Could I ask you to address that, Acting Commissioner?
Thanks, Elta. The issue of priorities is something that ideally we could move into, but looking at our mandate as a commission, our sole purpose of existence is for us to give redress to consumers. So what consumers are complaining about in this given space, it's what takes a priority. Though, as you could have heard also from the Competition Commission, is that they would look at bigger firms and maybe looking at the thresholds. But from our side as the NCC is to look at those conduct that will affect a larger proportion of consumers. As you would have seen, let's say, with your Ford Cougars and all that, you would see also with your product recalls and all that. So we would really, when we're looking at as when we do inquiries, we determine exactly under which market that affects a number of consumers who would like to do an inquiry on. But when it comes to our investigation, we look at the number of consumers that are complaining about a particular practice. And if that practice is not actually if we don't intervene, it would cause more harm, then that becomes a priority. So we have two folds, your complaints that determine that and the impact it has on our consumers. But also, again, our act is even precise to say that we have to give more consideration to the harm that is suffered by the most vulnerable. And the most vulnerable, we're talking about your elderly persons, people in the remote areas, people with disabilities, your women, and your children as well. So those are the people that when they complain, it could be very small, like as you would see, if maybe we have a product that we know that it is under recall, but then it's being served to your children, like your apple juice or something like that, that becomes a priority for us to say, this is essential, let's deal with it urgently. And then you're looking at maybe also your product recall like we did with Ford, because it also affected families, a number of consumers that were suffering, that would suffer, but also it would affect you, even if you're not driving that vehicle by then. If that incident happens to you, that becomes a priority. But what we are looking at as the Commission is that when we see some of the matters that are emerging, like what you would be seeing now around the issue, because our most emerging markets is around the automotives, where it is like the fixing of your second-hand vehicles and all that. You would see that the Competition Commission is already looking into that, and then we are coming together to say, from the consumer protection side, what is it that we can do to make sure that that area wherein there is a need to bring in your smaller businesses, then we can come in and really intervene from the consumer protection side. Thank you.
Thank you very much, Acting Commissioner. I would just like to pose a question to Aidan at this time. So Aidan, from the side of private practice, what are your views on potentially both the NCC and the Competition Commission potentially prosecuting parties for the same conduct under two separate pieces of legislation?
Thanks, Sarah. Sorry, thanks, Althea. It's a good question. I mean, I think the Deputy Commissioner did touch on it a bit. I mean, I suppose, there is I suppose you could argue a sort of a question of fairness and sort of a double jeopardy type of argument, where you say, well, if the same conduct is sort of giving rise to prosecution under the Competition Act and under the CPA, is it really sort of fair to prosecute that firm twice? I mean, if the intention or the objective of prosecuting them is to sort of firstly stop the conduct, but then also to sort of punish it and impose some sort of penalty, is anything gained by doing that twice? And I mean, I guess I suppose that becomes kind of a policy decision and a policy discussion about sort of use of resources and those sorts of things. I mean, I guess from a legal perspective, I would say that technically, if the conduct does give rise to an offence under the Competition Act and also under the CPA, then it probably is permissible for a firm to be prosecuted twice. But as I say, there is, I guess, sort of a policy question there about whether, given potentially constrained resources at both regulators, whether that is the best way to go about it, and whether perhaps by sort of casting the net wider and sort of letting the Commission focus on sort of one complaint and the NCC on another, whether you might, I guess, capture a wider range of conduct and potential offences.
Thank you. Ira, 2020, as we all know, was certainly a busy year for both the National Consumer Commission and the Competition Commission. What stood out for you in terms of the cases that you saw being brought and prosecuted and settled by the National Consumer Commission?
Thanks, Althea. I'll just have a look at the Lynx Chemical case that was referred to the National Consumer Tribunal. So what happened here is, during March 2020, the Commission received a complaint from a business which purchased hand sanitizer from Lynx Chemicals. So the complainant alleged that he ordered 3 containers, 25 litres of hand sanitizer at 990 Rand each. And he received the first container at that price, and then got a quote for almost 2,500 Rand per container for the remaining 2 containers. And this appeared to be an instance where the supplier was inflating the prices and being in contravention of the disaster regulations. The NCC decided to investigate this complaint and appointed an inspector. And based on the inspector's findings, the NCC then lodged the application with the tribunal. Interestingly enough, the tribunal concluded that although Lynx's invoicing practices can be regarded as suspicious, the NCC wasn't able to prove that they contravened those regulations, those disaster regulations, those two tests that Aidan and I were talking about. So I assume in practice, it is quite hard to sometimes show these contraventions based on these tests. Back to you, Alte.
Thank you, Ira. And I think one question that I'll pose to both the Deputy Commissioner and the Acting Commissioner, and I suppose we can start with a response from the Deputy Commissioner, but we've been talking a lot about the pricing aspects of the interplay between competition and consumer law. But where else do you see overlap between the two pieces of legislation, and where else do the Commission and the NCC anticipate there being the greatest scope for collaboration? Deputy Commissioner?
All right, thank you very much for that. I think, and of course, I think the issues, the pricing questions are quite crucial, and I think, this is where we have sort of direct overlaps in a way, but with different tests. And if you look, even the disaster management regulations, they were very specific, in specifying a test for cases under the Competition Act, because the Now Act allows the minister to pass those regulations to prescribe a test, right? And of course, that was a test that enabled us to tackle some of these cases. It was more like a very simplified test. So you look at the margins historically and whether prices increased. So those are sort of not the usual cases you get. But if it becomes a standard, that would definitely make it maybe much more easier for the Commission to pursue such cases in the future. But that standard is for that only. But with the Consumer Protection Authority, we are seeing a more scope in advocacy, because I think that is also very important to educate consumers, because we join hands, educate consumers so that they know which kinds of cases should they be bringing forward to the Competition Commission, and which kinds of cases should they be bringing forward to the National Consumer Commission. So if you look at it, we had received over 2,500 complaints, as an example. We probably prosecuted just under 40. Prosecuted, I mean, entering into consent agreements or prosecuting contested matters. I think we only had 2 contested matters in Babaleki and Diskam. So we see that if we can educate, I think we need this joint collaboration, efforts to educate consumers as to how, where best should they be filing their complaints. And I think that will avoid that question, of duplication. But for us, that is not so much a big problem, because I can assure you that we refer, more cases to the National Consumer Commission when they come through. So I see us jointly sort of working together more in educating consumers. And I think there's more scope now in the region also. We were just negotiating tripartite rules on competition policy. I think there's going to be a lot of scope for collaboration between the 2 authorities, but also even in sharing capacities. We think, we can also learn from each other, by, seconding staff either to the other side, the second staff to the Commission, so that we also do not take for granted that we fully understand, the other statutes. So that is what I see us doing more into the future.
Thank you, Deputy Commissioner. So Acting Commissioner, we'd be interested to also have your views on that question of collaboration in future.
Thanks, Alta. The area for us really of interest, I would really just point you towards what we had, especially around the price gouging, on the second round of complaints that we had received in July. What was interesting is that we looked at ways in which we can tackle the problems better, given the complaints that we had received, as the Deputy Commissioner has said, is that from our side as the NCC, it was really to look at redress. But what we did in collaboration is that when you look at the different mandates, is that who does what? You will see that based on the Competition Commission on their act, it's really to deal with business to business. And then what we do is to deal with business to consumer. So what that does, the collaboration, is that from the competition side, we can be on the preventative side, while in the CPA, we can be more on the redress side. So that collaboration of like saying when we have a phenomenon that we wanted to look at, who does that better? And that also would also look at when there is a contravention. Our act is clear to say that when there is any contravention wherein we would have investigated the matter together, that piece of legislation that will give better redress will prevail. So that would mean that that synergy, working together in one investigation and coming together with the recommendations and contraventions, then if we do that, then it will assist us to say, you take the matter further into your own tribunal because we will get better redress there. But another area of collaboration, just to add on what the Deputy Commissioner has said on the education, is around the issue of research. Now, when you are looking at the issues of dominance, and then I think that also happened with the issue of the cartels around bread and all that, is that we see this dominance, we see the pricing and all that, but does that trickle down to I as a consumer in the price of my bread? Because what consumer protection does is that that redress should actually go back to the people that have suffered detriment. So if we do better research together and find ways of saying, when we are looking at sanctions, how do we then look at those sanctions that we will be looking at? Could it be maybe entering into when we actually enter into a consent agreement to say, how will that consent agreement benefit the person that is the ultimate receiver of that good, or who really suffered the detriment? So those are the areas I think that would be a better way, a better fit moving forward, wherein we do our own researches and then look at better ways of saying, when we are looking for redresses, how do consumers ultimately benefit from both legislations? Thank you.
Thank you, Acting Commissioner. Mindful of the time, our hour slot is almost up, but I wanted to just give a very, very warm thank you for all of the insights that have been given to us by the Deputy Commissioner of the Competition Commission and by the Acting Commissioner of the National Commission. I'd also like to thank Ira Gunning from our Banking and Finance Department and Aidan Skellen from our Competition Department for the insights they've given to us as well. And thank you also to all of our attendees.